Hello everyone. In this presentation, we will discuss about the parties to a suit. In the first part, we will discuss about the capacity to sue, and in the second part, we will discuss about the capacity to be sued. The general rule is that every person has a right to sue and can be sued for a tort. However, there are certain exceptions to this rule, and some persons are considered incapable of suing the defendants for torts committed against them. These are convicts, alien enemies, husband and wife, corporation, unborn child, insolvent person, and foreign sovereigns. Now, coming to the first category of persons, that is convicts. Who is a convict? A convict is a person who is convicted for an offense and sentenced to imprisonment. Under English law, until 1948, a convict had no right to sue for any injury to his property or for recovery of debt under Forfeiture Act 1870. The Criminal Justice Act 1948 removed this disability. The Indian law on the point is the same, and hence a convict can sue a wrongdoer for personal injury as well as for injury to property. Now, regarding alien enemies, who is an alien enemy? Alien enemy is a person of a nation in enmity with the subject country, or a person residing or carrying on business in enemy territory, whatever may be his nationality. Under English law, an alien enemy has no right to sue in his own capacity. But if he was residing in British Dominion, he could sue with the express or implied license of the Crown. In India, under Section 83 Civil Procedure Code, an alien enemy can sue in India for a tort with the prior permission of the central government as if he was a citizen of India. But alien enemies residing in India without permission cannot sue in any such court. When an alien resides with the permission of the government, he gets the protection of the laws of the country and hence can sue for violation of rights with the permission of the central government. Regarding husband and wife, under English law, prior to 1962, married women could not sue for any tort committed by a third person unless her husband joined her as plaintiff. This was because husband and wife were considered to be one in the eye of law. The husband and wife also did not have a right to sue each other for the tort committed by one against the other. But the Married Women's Property Act accepted an exception to the rule and allowed the wife to sue the husband for the protection of her personal property. By Law Reforms Husband and Wife Act 1962, the husband and wife were given equal status and hence could sue each other as if they were not married to each other. The court can stay the proceedings against each other when it feels that the suit is being used for trivial domestic dispute without any substantial benefit to any of them. Marital status in India is regulated by personal law and not by tort law, and marriage under personal law does not affect the capacity of the parties to sue each other and also does not confer any protection to any of the spouses for any tortious act committed by one against the other. Now, regarding corporations, corporation is a legal entity and enjoys certain rights and has certain duties. It is independent and separate from its members and hence can sue and be sued in its name. It can sue in its own name for defamatory statements, harming the reputation of the corporation, or for torts affecting its property or business. It cannot, however, sue for personal injuries because personal injuries like assault, battery, etc. cannot be committed against a corporation. Corporation being an artificial person acting through its servants or agents, if an agent or servant commits a tort in the course of his employment, the corporation would be liable on the basis of principal-agent relationship. Now, regarding the unborn children, so far as prenatal injuries inflicted to an unborn child is concerned, when the child is born and is born with a disability, an action on behalf of an unborn child can be brought against the person who is responsible for the act of causing the disability. When the child survives at least for 48 hours after birth, damages can be awarded for expectancy of life. Even where the mother is responsible for the child to be born deformed, she would be liable, and if the child remains alive for 48 hours after birth, damages for expectancy of life can be awarded. In India, there is no such law governing the liability for prenatal injuries to unborn children, and hence guidance can be taken from the decisions of the English courts. In the case of insolvents, under English law, the general rule is that an insolvent cannot bring an action for any wrong committed against his property, because an insolvent's property, whatever is left, is vested in the trustee, that is, official assignee or receiver. In the case of personal injuries, he can sue the wrongdoer for damages when the injury caused is both to his person as well as his property. The right of action splits, and with reference to personal injuries, insolvent can sue, whereas for injury to property, the official assignee has to sue. In such cases, a joint action can be initiated by the assignee as well as the insolvent. In India, English law is followed in this aspect. In the case of foreign sovereigns, they can sue for torts in the Indian court when such state to which he is sovereign is recognized by India. However, permission of the central government has to be obtained before filing a suit. Thus, this presentation was about capacity to sue, and the next one would be on the capacity to be sued for torts. Thank you.